Yes.
Yes, okay, good. Again, thank you for having me. Normally, Nancy Nicolescu, our Director of Education, conducts these meetings, these trainings. But again, she's not feeling well, so I'm in her place. I know you had a lengthy meeting, and I'm just to make sure that this is just the staff of the Green Bank, or is this also we have members of the board as well?
We have some board members also. Some of our board members are also with other agencies, so they'll be getting their ethics training through them, whether it's OPM or DEEP, and then but others are staying on, and the ones that aren't, either we'll provide other options for them.
Got it. Thank you, Brian. That's helpful because this way I know how to tailor this presentation in terms of the audience. So I'll just cover a few basic subject matter items under the Code of Ethics. Some of you have already had this training. Obviously, there are a couple of new things, but by and large, if you've heard this before, this is more of a refresher for you. Clearly, the main points we'll cover involve gifts and necessary expenses, conflict issues, also outside employment, revolving door, and briefly at the very end, SFIs. As you already know, all public officials, state employees, lobbyists, and state contractors are subject to the state codes of ethics. Generally, if you're looking for a common thread for all the provisions of the codes of ethics that we administer, the common thread is financial misuse of office or position for financial gain. That's generally when you look at gifts or conflicts or what have you. That's usually the basic thrust of the code of ethics. Obviously, the discipline of ethics is very broad. You can be approached by your neighbor about ethics. You can talk to your kids about ethics. But when we talk about here on the in our jobs on the state level, it's really financial conflicts of interest. That's the gist of what we administer. At the outset, Nancy and we all emphasize it is critical whenever you're faced with an issue, whether you have a question or whatever, always seek advice from our office. We're available. We are your resource to you. So if you have questions about outside employment, you're leaving the state, revolving door questions, by all means, please seek advice. Some of these questions are very fact specific. So they may be very particular or nuanced to your situation. There may also be questions of kind of general applicability. So it all depends. But whenever you have any doubt, please contact our office. Also, each agency, including quasi-public agencies, may have their own internal codes of ethics or ethics policies, to be more specific. And those policies may be more restrictive or may be addressing issues, may address issues that are specific to your agency. So it's important to familiarize yourself with that. Now, they can be more restrictive. They cannot be less restrictive than the state code of ethics. Really, the state code of ethics is the foundation. It's the basis of our ethical conduct. Also, some of you within the agency may be designated by law as mandatory reporters of ethics violations. And those folks are generally agency heads, their deputies, folks who are in charge of procurement at your agency, folks who are in charge of human resources. So keep in mind that by law, you are required to be a mandatory reporter if someone comes to you with substantiated allegation and you have reasonable belief to that violation did indeed occur. So you have to report those findings to our office when they come to your attention. All right, I'll move quickly to these basic provisions. We'll start with gifts. Generally, the policy is do not accept gifts. We have a statutory definition of what a gift is, and generally it is anything of value that's directly or indirectly received unless consideration of equal value is provided. Now, we have several gift exceptions, and I will only cover the most common ones that you may encounter in your state service. There are also other gift exceptions that deal with particular situations, but again, the basic ones, deal with token items, accepting anything of value that's under $10. That's permissible. Your cup of coffee, whatever. That when you interact, particularly with folks that seek to do business with your agency or are doing business with your agency. And before we actually go to the exceptions, just a quick overview of who are the potential donors that you may encounter. And obviously, the folks that you really have to be concerned about are the so-called restricted or regulated donors. They are obviously the contractors, the folks who are seeking or are doing business with your agency. Registered lobbyists, and those are the main or the likely folks who would fall into that restricted category. And for them, strict gift limits apply, and they are prohibited from giving a prohibited gift, and also you are prohibited from accepting a prohibited gift, other than those exceptions that I'll cover very soon. And you have also another group of folks. The secondary group of potential donors are considered non-restricted, but they're giving something to you by virtue of your service, state service, or your job at the Green Bank. Let's say it could be your counterpart, for example, in another state. Let's say another state that has a similar agency such as yours may hold a conference, and let's say they provide certain items to you. Clearly, they're provided to you by virtue of your employment with the Green Bank, not because you for some other reasons. So those are obviously also considered. There may be some restrictions imposed on those folks. They're considered non-restricted, but limits do apply, and usually it's all the gift exceptions that I'll discuss plus additional $100. And finally, you have the last group of folks who are giving you something by virtue that is absolutely not connected in any way to your state employment, to your work for the Green Bank, to your family members, your friends, and so on. Just keep in mindful if you have a longtime friend who with whom you've been exchanging gifts on the annual basis for holidays or what have you, if they ever become a registered lobbyist in this state, then obviously strict gift limits would be triggered, and you would be subject to the limits that I'll discuss now. Now, I've mentioned already token items. There are also food and beverage exceptions. When someone asks you to go out to lunch, food and beverage up to $50 per year per source, so it applies to a specific donor, and that donor who pays for that lunch has to be present. So gift certificates to restaurants are not permissible if they're offered to you by a restricted donor. Token items, rebates and discounts that are generally available to the public are fine. For example, let's say in your in your world, for example, there may be provisions of discounts and so on to promote green energy, and you may partake in them so long these are offered and available to the general public. So that's fine. Ceremonial plaques, if you receive an award from an organization in your official capacity, or any I don't know how we would disclose, whether plaques or awards that you can hang on the wall, those have to be limited up to $100 if, again, they're given to you by virtue of your state position, your quasi-public employment. Other gift giving, obviously, there are major life events that you may partake in. Let's say a lobbyist may offer you, and that this provision applies to lobbyists only if we're talking about restricted donors. They may give you a major life event, gift for a major life event, i.e. wedding, birth of a child, retirement from state service, religious, entry into religious adulthood, you have death in a family. That's permitted, can only be provided by lobbyists. However, some lobbyists also wear state contractor hat, so that's fine. However, state contractors who are not lobbyists may not utilize the major life gift exception. So again, in that regard, that's fine. Now, gift exceptions, major life event, or any other gifts are permissible among colleagues. Let's say you may have a colleague within your agency that is getting married. Colleagues may utilize the major life event gift exception as well. For ordinary gifts that are not considered major life events, the gift giving among colleagues is not limited in any way. However, if we are talking about someone who is in supervisory or subordinate relationship, and it goes up and down the chain of command, excuse me, those type of gifts are limited to up to $100 per gift. Another area of gift giving you may encounter, and that's fairly common, is gifts to the state. You may have organizations, both restricted and non-restricted, that want to offer items for state use by a state agency, including quasi-public agency. Gifts to the state are permissible. Lobbyists obviously have financial obligations, financial reporting obligations to report those gifts on their financial reports. You may also utilize gift to the state if you are an employee who is being invited to a conference, let's say out-of-state conference by some national organization. They're inviting you by virtue of your official position, but you're being invited there in your passive role. In other words, you were there to learn something, new developments, and let's say clean energy financing, using that as an example. And you have experts, and they obviously impart certain knowledge to you. You may attend a conference for that purpose to learn something, and that is permissible under the gifts to the state. It has to be reported to the Office of State Ethics within 30 days of attending the conference, within 30 days of receiving benefits for traveling to the conference, staying in a hotel, and any registration fees. Clearly, any additional perks that are offered by the organizers of the conference, let's say Broadway shows, golfing, or what have you, more type of on the entertainment side of things, that has to be covered out of pocket. It's not permitted under gifts to the state, because essentially the policy behind gifts to the state is, what would the state pay to send you out to the conference to learn something? And clearly the states, I doubt, would be willing to pay for golf or Broadway shows. So that's generally the approach for gifts to the state. Now, there is a mirror provision for that. It's called necessary expenses. Now, the difference between necessary expenses, sometimes folks think of it as a gift. It's not a gift. It kind of mirrors the gifts to the state requirements, but with two major distinctions. One, it's not considered a gift because under necessary expenses, you are attending an event to provide your expertise to others. You are there to impart knowledge on others. You are invited as a guest speaker, as a panelist, moderator of the panel. And under necessary expenses, unlike under gifts to the state where your attendance can be passive, under necessary expenses, there is a requirement for active participation. So you really have to be invited as a speaker. You cannot just be a guest in the audience. And again, similar reporting rules apply within 30 days, and also it's limited to those necessary items that are furnished to you by the organizer, by the sponsor of the event, i.e. hotel, lodging, food, beverages, and travel costs. I think that's all on gifts and necessary expenses. I'll move on to the next major area, and that is conflicts of interest. You most likely have heard about substantial and direct conflicts, and also potential conflicts. Under our code, obviously the substantial conflicts require mandatory recusal whenever you're faced with one. Under the provision that deals with substantial conflicts, you have a direct conflict if you believe or expect that your immediate family members, any associated businesses will derive some distinct financial benefit that is distinct from other groups, other organizations, general population, and so on. So again, it would be a direct conflict using that example of rebates, receiving a rebate that's exclusive to you, where you award yourself a rebate that's not available to the general public about some kind of purchase of clean energy product and so on. So because again, it will be self-serving, it is for your own benefit, and it's limited and as to who benefits. It's either you, your family member, or any associated business. Now, direct conflicts have to be immediate. There's no intervening condition required. So it's essentially doing X, and the result is your financial benefit that it's exclusive to you. As I said, recusal is required in those situations. Now, you may also encounter potential conflicts, and under potential conflicts, a public official or a state employee normally would be faced with a conflict where they have a reasonable expectation that they will likely derive financial benefit from their official action. And again, the standard, the test for potential conflicts is that there's this reasonable expectation that you will derive financial benefit, and also either your family members, immediate family members, or any associated businesses. It has to be reasonable expectation, likely that is, as opposed to merely conceivable. We know that in this world, anything is possible, but this has to be something that is likely to happen if you take official action, that you will derive financial benefit. Now, unlike under substantial conflicts, you do have an option of recusing yourself from under potential conflicts, but you also have an option to, that there is, if you're a board member, you may, obviously, you are required to make a statement. If you wish to act on a given potential conflict, you have to disclose that conflict on the record in front of the board, and you must make a statement that that despite the conflict, you are acting in the best interest of the general public. That's a requirement for board members. You either have to recuse yourself or issue that statement, and a copy of the statement has to be furnished to the Office of State Ethics as well, in addition to placing it on the record of your proceeding. For employees of your agency, if you encounter, for staff members, if you encounter a potential conflict, you're required to either recuse yourself or you're required to inform your immediate supervisor, who will then assign the matter that creates a potential conflict to a fellow employee who's either of equal rank or someone who is another supervisor. It cannot be a subordinate to whom that would be assigned. And finally, again, one more note about potential conflicts. Just like under substantial conflicts, if the benefit accrues to the general public, a broader universe of folks, a group of individuals than just, let's say, a small universe of your agency, or again, it has to be much greater kind of in that sense, then it's okay to act. And finally, I'm going to touch upon just briefly, because this issue is raised before us frequently. Are you subject to an appearance of a conflict? The answer is no. Under Connecticut law, the ethics codes are silent with respect to appearances of a conflict. You have no legal obligation to abstain when you are faced with an appearance. Now, having said that, what we tell folks is that's really left to your discretion. Some folks, especially if you're more of a public figure and subject to a greater public scrutiny in the media, you may take a pause and decide, well, the optics are not good, and you may decide, and again, that's left to your discretion, to abstain from taking official action, even if it's just an issue of an appearance. Again, it's not legally required, but just to let you know that under our law, the code is silent with respect to appearances. Now, I'm going to move to, so that's all on conflicts. The other major area is obviously outside employment. And whenever we deal with outside employment questions, those are very fact-driven. We highly recommend for both outside employment and revolving door questions to contact our office if you are faced with one, because especially if the outside employment is somewhat close to what you do for the state, for your quasi-public agency, the subject matter, and so on. Now, clearly, if you're pursuing outside employment that has no connection whatsoever to what you do for the state, to what you do for the Green Bank, you don't have to contact us. That's permissible, so long as you do it on your private time and not on state time, and you do not utilize state resources to facilitate that outside employment. Now, for situations where there may be some overlap, or for example, it deals with a subject matter that's somewhat close to what you do for the state, clearly there are specific guardrails in place. One is you may not accept outside employment that will impair your independence of judgment as to your state duties. So clearly working for seeking employment with a company that has regular business before a Green Bank, that would be problematic. Also, you may not use your office, your position, to advance your outside employment and also benefit your private employer in the context of your state job. And finally, you may not disclose any confidential information that you've learned in your state service and your work for the benefit of your private employer. But as I said, again, it all depends. As I said, it's fact-driven. It all depends who you're pursuing the outside employment, private employment with, and that's why it's important to check with not only with your agency. You may have an internal policy. Some agencies, for example, require clearance, internal clearance for private employment. And also, if you have additional questions from us, absolutely, please contact us. Now, One other major topic I want to touch upon is revolving door questions. Now, there's been a lot of talk about revolving upcoming wave of retirements in state service, involving state service, especially next year. So revolving door provisions are really a hot topic with our office. We're getting many questions in that area. There are essentially 4 basic provisions that deal with revolving door questions. There are 2, what we call them, lifetime prohibitions, and 2 one-year prohibitions involving post-state activities. Quickly on the lifetime bans, the first one is common sense ban. You cannot use confidential information you've learned in state service in your state work for your benefit and benefit of others following your retirement from state service. The other one is site switching prohibition, and this one is really narrow in its application, and it applies to situations where, for example, you were directly, personally, and substantially involved in a negotiation or award of a contract grant to a private party, and you end up seeking post-state employment with that party to that contract. What that provision prohibits you from doing is representing that private party before Green Bank regarding that particular contract you handled while in state service. You may handle other matters that are related to the Green Bank, but not that particular matter that you've worked on while being employed by the Green Bank. This is a lifetime prohibition, and again, it applies specifically when there are some controversy. There may be litigation involved regarding the contract, or some other aspects where the interests of the state, of the Green Bank, are at odds with your private post-state employer. So again, it's a lifetime ban on that particular matter, involvement in that particular matter. Then we have 2 one-year bans involving one is what we call a cooling off provision. It essentially prohibits you from representing anyone, and here are the key terms, for compensation before your former employer for 1 year from the time you leave state service. So if you end up working for someone and you will have to abstain from representing that private employer before the Green Bank for 1 year. You may represent that private employer before any other state agency, any other quasi-public agency. It's an agency-specific prohibition, so it applies only to your former agency. Now, I think some board members, there may be board members who are also involved or represent other agencies or serve for other agencies. That prohibition, the cooling off prohibition, applies to each agency in which you serve. So again, it's for 1 year. And again, it's for compensated representation. So if, let's say, you decide you truly retire and you're not deriving you're not engaging in any other employment, you may represent someone pro bono within that 1 year before your former agency. But again, it has to be truly pro bono representation. It's not kind of a future promise, a promise of future compensation, let's say 1 year from now, because that really defeats the whole purpose of the law. So there has to be absolutely no compensation involved in that type of permitted representation. And finally, the last item, it's a 1 year ban, and there's a provision that is specific to quasi-public boards, and it deals with quasi-public board members, where it says that no member or director of a quasi-public agency who participates substantially and personally in a negotiation award of a contract in excess of $50,000. So the contract has to be valued more than $50,000. And it also applies to folks who supervise negotiation or oversee the entire contracting process. You may not seek, accept, or hold employment with a party to that type of a contract for a period of 1 year after the signing of the contract. So, again, the sequence of events has to be very is important here. So if the contract's been signed and then you leave state service, you are prohibited from pursuing employment with the recipient of that contract for 1 year from the time the contract has been signed. There is another mirror provision in the code that deals with the prohibition on pursuing employment, and it's broader in scope in the sense it's broader because it doesn't apply necessarily just to quasi-public. It applies to all executive branch agencies. It's pursuing employment if you're involved in $50,000 contracts valued at $50,000 plus, pursuing employment with a party to that contract within, if the contract was signed within the final year of your state service. So that's all on in terms of revolving door questions. I've also mentioned SFIs as one topic of import. One update regarding those, for those of you who file statements of financial interests with our office, and those are due every year on May 1st, and you are required to report various things for the preceding calendar year. As of October 1 this year, we are only dealing with electronic filings of statements of financial interests. So we're no longer are accepting paper submissions of statements of financial interests. So if you've been doing or filing paper SFIs with our office up until now, you will have to switch to electronic format. And it's very straightforward. I think the first filing is maybe more involved because you have to do all the input. But once you do it, everything is actually held there. So you just have to do updates from year to year. So it's fairly straightforward. Those of you who already file electronically know that it's straightforward than more straightforward than paper version or paper filing. I will stop now and I'll entertain any questions you may have. I just wanted to give you the basic overview of things. One aspect, I usually try not to focus on enforcement of things, but it's important just in case if we have folks who transgress and have to deal with our enforcement division. Our enforcement division pursues enforcement of ethics upon filing of complaint. That complaint can be filed with our office by any member of the public, anyone, and our folks in enforcement conduct quickly initial investigation, preliminary investigations, just the basics to determine whether there's jurisdiction of our involving our office, subject matter issues, and so on, and then they quickly determine if there are grounds, if there's substantial evidence to proceed further to a probable cause hearing, then they will notify the subject of the complaint, the respondent. Now, if they also determine that there's really no grounds to pursue a complaint further because for lack of jurisdiction or what other reasons, folks who've been the subject of complaint will receive very quickly, and usually within 5 days, two things: a notice that a complaint's been filed against them, and second, automatic dismissal. And the purpose of this is for you not to lawyer up, because obviously hiring an attorney can be an expensive endeavor, especially in those situations where there's nothing for you to be concerned about because the complaint doesn't contain true allegations or whatever reason. Now, once it's determined that indeed complaint is valid, proceeds to probable cause hearing, all of the all the proceedings, the filing of the complaint, initial investigations, and the probable cause hearing itself is confidential. Things open up only or become public when a judge, trial or referee makes a finding of probable cause. And then obviously we proceed to an open hearing before our board, and the board determines whether there's a finding of ethics violation. But there's an entire mechanism, procedural mechanism and due process mechanism for you to, when you're dealing with enforcement. Also, one last thing before I take any questions, it's critical to emphasize that the Office of State Ethics has an internal firewall between legal advice side of, that is compliance side of our work, and enforcement. And the purpose of this is for you to be at peace in terms of, and also comfortable in approaching us and asking a legal question, advice question. It's obviously important to ask for advice before you take official action, and that shouldn't be grounds. The mere fact that you were contacting our office to obtain advice, even if it's determined that, well, you may already have violated the code, that communication with the compliance side of our office, with the legal division, cannot be subject for an enforcement proceeding. And it's really well-designed process, because, again, that will encourage folks to ask questions, to seek advice. This way you can avoid any engagement with our enforcement division. Okay, I'll stop right now, and I'll be happy to answer any questions you may have.
Great, thank you so much, Peter. And quite honestly, the questions that we typically get, like if it's from a board director, it's like, hey, I have some connection to this organization. And the reality is most of our resolutions pass by unanimous vote. So I'm like, when there's any question, typically, unless it gets really silly and removed, I say just recuse yourself. And then from the staff level, you know, we'll get questions of like, hey, so-and-so wants to invite me to a golf outing or to a concert. And then I'm usually having to be the bad guy and say, that's not something that you can do. If you can figure out what the fair market value of it is, you could potentially pay for it. And then the other item that often comes up is, hey, they want to take us out to dinner, and the monetary limit on what they can spend while they're present for you. I mean, those are the big things. Then the holiday time, obviously, with the gift baskets and making sure that those are shared with everyone. But those are kind of traditionally, we haven't really had many revolving door issues. The big issue with that came about when we spun out a nonprofit, but then we went to the ethics board to get approval for it. So, so it's been, knock on wood, we've had a pretty decent handle on, the ethics questions and no major curveballs.
Oh, that's great. That's good. And by the way, about those gifts, you may be attended to a golf outing or dinner. You also have an option. You have 30 days to compensate the donor, or if you decide, I don't want to be. Let's say you're dealing with someone who has to report that type of benefit under financial reports, i.e., a lobbyist. Folks sometimes decide after the event, after the golf or dinner, I'm going to reimburse that person, so I'm not showing up under financial reports. And it's only the lobbyists who are required to report the provision of some of the items. So you always have 30 days to reimburse. That's always an option.
Yeah, and the other item that comes up is travel. Hey, you want to pay for me to go to this conference in Arizona, or they want, they're to speak. I'm like, okay, well, you're going to go through our existing protocol where we're going to reimburse you, and you're going to do it through a reimbursement to us, and then they will reimburse the Green Bank directly, is how we handle that. So
that's fine. Yeah, as long as, there is some audio thing. As long as it's papered, in other words, it's documented that clearly the reimbursement occurred between the bank and the so it's essentially the bank that is the Green Bank is paying for the employee.
Correct. Exactly. Yep. Yeah. And that's it. I don't know if anyone else has any other questions. I know we have a hard stop, I think, at 12:15. But if there's any other questions, please ask them now.
I know you had a long meeting, so.
All right, perfect. All right, well, thank you guys so much. And if there are any other follow-up questions, obviously anyone on this can send them to me. They can send them directly to the Office of State Ethics. And, you know, the saying really does hold true. When in doubt, seek out and ask for advice.
Thanks very much.
All right, thank you so much.
Thank
All right,
you.
thanks, Peter. Thanks,
Thanks.
Thank you for having me. Thank you.
Thank you.
Thanks all.